Good morning, everyone, and welcome to this new coffee talk from our firm. Today, we're discussing a very interesting topic, which is the issue of cybersecurity and the use of AI to improve cybersecurity systems at the national level and also through relationships with the private sector and new tools such as public-private partnerships. This is why I'm not alone today. I'm here with my brother, attorney Andea Stefanelli, who is an expert in this field. Before we begin, I wanted to remind you that we've decided to do a series of coffee talks. All of them are aimed at analyzing Law 132 of 2025, which is the law on artificial intelligence. So we have a series. This is a coffee talk that is part of a series of coffee talks in which we analyze the articles we consider to be the most interesting in the law. So if anyone hasn't had the chance to follow the other live sessions, they can still find them. On our firm's website, we have a very powerful search engine. So go to our site, use the magnifying glass to search, of course, for coffee and artificial intelligence, or even just artificial intelligence, and you'll find all our other talks. So coming to today's topic, as we said, AI and national cybersecurity, Article 18 of Law 132. This article is a very short one, but in some way, in my opinion, it opens the door to important initiatives in the field of national cybersecurity. It's not a standalone article, meaning it's not a continuous independent regulation, so to speak. It amends Decree Law 81 of 2021, which was later converted into Law 109, also of 2021, which established a framework and institutional infrastructure for national cybersecurity, defining and establishing that the ACN is the autonomous public body of reference for this issue of cybersecurity. Now, without obviously analyzing here, because that's not our goal, everything that could be said about it. Decree Law 82 of 2021. The important thing is that among the tasks assigned to ACN by this decree law, there were obviously no specific tasks, nor was there any provision for the use of artificial intelligence systems to enhance, monitor, or in short, improve the national cybersecurity system. It could probably have been considered implicit, but the legislator instead deemed it appropriate to clarify it. So by adding this letter M to the list, in Article 7, Paragraph 1 of Decree Law 81, it is clarified that ACN must promote and develop initiatives also through collaboration with private entities and public-private partnerships to enhance artificial intelligence as a resource for strengthening national cybersecurity. So it's not so much about how to use, let's say, this is not a regulation, unlike some of the other rules we've seen. This is not a regulation that it does not set rules to control the potential risks of using artificial intelligence, but rather it is a regulation that opens up the possibility of using artificial intelligence. In fact, it promotes it, it says. Specifically, the regulation encourages the use of artificial intelligence to improve cybersecurity, infrastructure, and the control of cybersecurity at the national level. So in this sense, the legislator considered it appropriate, as I mentioned earlier. Perhaps it could have been considered implicit within the responsibilities of the ACN, but the legislator still deemed it appropriate to include a specific point assigning this task, this duty of promoting development directly to the ACN. The aspect that I find even more interesting is precisely the fact that the possibility to carry out this activity is provided for. Thank you. Through collaboration with private entities and through public-private partnerships. So now, as we will see, in reality, the current regulatory framework already allows the public administration to develop collaborations with the private sector, but the fact that the legislator wanted to clarify this point, I consider this to be a very interesting aspect. Interesting. By the way, I'd like to point out, if anyone happened to see it over coffee, the part concerning Article 8 of Law 132, the one about scientific research, about the use of health data for scientific research and for the development aimed at the development of artificial intelligence systems. There too, collaboration with the private sector is mentioned, providing the possibility for private entities collaborating with the public sector to use as a legal basis the public interest and to use the data for secondary purposes, to anonymize them, to synthesize them. So let's say within Law 132, there is a sort of common thread that highlights not necessarily the necessity, but at least the lawfulness or the opportunity of developing public-private collaborations. Probably because the topic of artificial intelligence is a very new one, it obviously requires significant resources and expertise. So the legislator is aware that the private sector could be a very interesting partner for the public sector in developing these systems. Otherwise, perhaps the public sector wouldn't even have, let's say, the economic strength to do so. So having given this initial overview, as I was saying, the two key elements are first, an expansion of ACN's responsibilities with an extension of its duties and the introduction of AI to improve the national cyber sequence. And second, activities that can be carried out in collaboration or in any case through public-private partnerships with private entities. Now, on this point, which I believe is in some ways the most disruptive element of the regulation, I would like to invite to call my brother to tell us a bit about. He and I have studied this together, even in different fields, myself in healthcare and him in competition law. My brother deals with, apart from competition law, also public administration. So I would ask you to tell us a bit about what this partnership is, how it works, its possibilities, and its critical points.
Of course. So the public-private partnership, also known as PPP, is an institution that was already present in the first Code of Public Contracts, that is Legislative Decree 163 of 2006, but it has always been a rather marginal figure. Why is that? Because collaboration between the public and private sectors, when not formalized in the typical contracts of procurement, has always been seen as somewhat problematic. Over the many decades, however, this specific issue has gradually faded away and become less prominent, especially because, and particularly when the PNRR funds finally arrived, the legislator became completely and profoundly conscious of the fact that it would not be possible to deploy all the funding coming from Europe without utilizing and effectively leveraging the extensive know-how and project capabilities of the private sector, given, of course, the public administration's own significant challenges and inherent limitations in terms of project development. So, as a direct consequence of this realization, the third code, number 36 of 2023, was the code in which, for the first time, the institution of public-private partnership has not only been expanded, but has actually become the umbrella under which many other types of contracts fall. In fact, it has become the general category within which the specific type of concession contract is included, a contract which, as is well known, has been much more established and widely used in the public sector for decades. Partnership, and this is another very interesting aspect, is in fact the title of the fourth book of the code, Partnerships and Concessions. And in Article 174, it is stated that the public-private partnership is an economic operation, a procedural model. So for the first time, the legislator introduces a concept, let's call it biphasic, by which partnership is a procedural model, that is a procedural type for identifying an economic operator, the private party, who will then will enter into an agreement with the public administration, a non-standard contractual type, because Article 174 and the following articles provide for a whole series of contractual types, the most well-known of which is the concession. But there is also the financing contract, the availability contract, and other types of contracts, which are expressly referred to as well. To what? To Article 8 of the Code of 36, that is the section relating to general principles, where in Article 8, for the first time, the principle of contractual autonomy is established. That is, for the first time, it is established that the public administration is not obliged to enter into standard contracts, as was the case before 2023, but may also enter into non-standard contracts with private parties, obviously while respecting the public interest. The combined provisions of Article 8 and Book 4 of the Code, that is public-private partnerships and concessions, for the first time grant broad authority and opportunity to public administrations to enter into any type of contract, which, of course, must have as its objective the safeguarding of the public interest, the achievement of the public interest, and even the result referred to in Article 1 of the Code, through a procedural model that is specifically outlined by Article 174 and the following articles. Now, this procedural model has undergone two very significant changes. The first, introduced by the 2024 corrective measure, which came into force in 2024, and the very recent ruling of the European Court of Justice, which has eliminated the so-called right of first refusal from the partnership. You have probably read or heard news about these, and especially about this second change. Well, actually, even at first reading, some have interpreted this as a prohibition by the Court of Justice on the right of preemption, which we will now briefly see what it is. Some have said that in reality, this was a sort of definitive closure for the use of the partnership. In reality, this is probably not the case.
It's a de profundis.
In short, the first
reading was a bit terrifying.
Of course, the first reading, because let's say that the right of preemption was that mechanism which allowed the party proposing a partnership, therefore the so-called privately initiated partnership, and which allowed him, I repeat, since he was the one who proposed the partnership. So having drafted the project himself, and therefore having taken on both the cost and the effort, including the design effort, then at the moment when this project was put out to tender, and thank you, if the outcome of the tender did not go in his favor, the party still had the right to be awarded the contract in any case. Even if he was not the best bidder, he had the right to exercise the right of first refusal. The Court of Justice held that this right of first refusal violated the principle of protection and competition. And of course, we know that this is even more inherent in the Treaty of the Union, and therefore it had to be essentially removed from the Italian code. As we were saying, this fundamental shift in our current reality probably does not diminish the significant importance and the enduring interest that this partnership still continues to have. But why exactly? Because, as Silvia said, partnership is a tool that allows collaboration between the public and private sectors. And this collaboration must be aimed at achieving an interest for both parties. The interest of the public administration is precisely the public interest. And in this specific case of cybersecurity, it is, in fact, to introduce or apply artificial intelligence systems for national cybersecurity. For the private sector, it is obviously the opportunity to develop these artificial intelligence systems so that they can later also use them in the private sphere. So the public environment is used, or at least the opportunity to, let's say, to try out and test these systems so that they can eventually also be used in the private sector. So going back for a moment, what does the partnership essentially allow you to do? There are two instruments provided by the legislator. There is the partnership proposed by the public administration and the partnership initiated by the private sector, which is, let's say, the more interesting and more commonly used one, the private partnership initiated by the private sector. This is the one that, following the amendment of the corrective measure, allows a private entity to present its own project to a public administration, or rather to approach the administration and ask whether it is interested in developing or awarding a certain type of project. Once the public administration has verified that this project is of public interest, at that point, it declares the expression of interest in the project to be of public interest. And at that point, this is what the amendment establishes. It sets, that is, it launches a call for expressions of interest to ask the market to submit all possible projects that economic operators are able to present. So the private entity that has engaged the public administration obviously has its own project, which it will submit to the public administration, and the other economic operators in the market, if they are interested, can also submit a project. Once the public administration has completed the initial phase of verifying market interest, it selects one or more projects and decides to put them out to tender, thus initiating an actual tender procedure, typically based on the criterion of the most economically advantageous offer, with a series of specific requirements. These are particularly structured tenders. And at that point, it will choose, based on the outcome, the project it considers most suitable for the public interest. Here, before the ruling of the Court of Justice, there was a right of first refusal that had to be expressly provided for, which, as we have seen today, has been eliminated. But I repeat, this is not the factor that can influence whether or not the private party decides to approach the administration, for the simple reason that in this way, that is by submitting and engaging with the administration, the private party still has the opportunity to participate in a tender whose subject is their own project. So they are obviously at a significant advantage compared to other economic operators. It is clear that the economic operator, whose rightful entrepreneurial goal is to win the procedure, is evidently advantaged by a position of privilege. If they participate in a tender whose subject is their own project, it is because, obviously, they are aware of elements that may escape other economic operators and that allow them to be more effective in formulating their offer. Partnership is still a tool that allows the private party to have a competitive advantage, even though, as we said, the right of first refusal has been eliminated. And therefore, it is unquestionably one of the instruments that can be widely used and advantageous, specifically in the development of artificial intelligence systems in cybersecurity. And it is for this reason that the legislator, not by chance, has, let's say, generally allowed the possibility of making agreements with private entities, but specifically has also stated through public-private partnerships, making explicit reference to Article 174.
The impression one gets is that the legislator is indeed fully aware that the public administration cannot manage on its own, and therefore, in any case, it is appropriate to open the doors to collaboration with the private sector. So let's do the final scene, the final question that we always ask. Tomorrow, someone comes to our office who intends to propose a public partnership, private entities, specifically regarding cybersecurity. Of course, we will look into the specifics because here we will also need to reflect on it. Obviously, what could they be? What are the suggestions? What can we advise them? How can we proceed? What are they?
Well, I repeat, it's clear that anyone who wants to approach a public administration to present, as I mentioned after the corrective measure, cannot submit a full project right away, but must, let's say, present a project proposal or preliminary draft. So in any case, they don't have to bear the cost of the entire project, but they do have the advantage of engaging with the administration by suggesting a certain solution, which we know very well in the field technological. It can be a decisive solution compared to other options. So just the act of presenting a project that is considered to be of public interest by the administration is certainly a significant step.
Therefore, probably by reasoning, not only from the perspective, pure technology, but also obviously the possible contractual aspects or the assumption of business risk, let's say. So all those characteristics that in some way can make this project. It is
clear that every economic operator has its own particularities, which make it more competitive than other economic operators in certain respects and less so in others. So it's clear that in this project, he will highlight and emphasize those elements that are his competitive advantages. Therefore, it's evident that being able to participate in a tender where the aspects in which that economic operator has greater, as we say, advantageous aspect compared to others is undeniably an element that works in his favor when participating in the tender. So these are the suggestions I would feel to give to the potential, let's say, operator who intends to proceed in these terms. Well then, if by any chance any of you happen to be interested in the idea of submitting your own creative projects for consideration, please know that we are certainly available to help you out. We thank you for being with us to analyze this topic, and we'll see you at the next coffee break. Have a great day, everyone. Thank you very much.